Hi, everyone. Thank you so much for coming today to talk about the recent law that was passed, AB 1775, discussing or making changes to California's cannabis laws. First off, I just wanted to talk about who we are. You see us referred to as the Public Health Law Center, but we also go by the name of the Partnership or the Law and Policy Partnership to End Commercial Tobacco Epidemic. It's a partnership between the Public Health Law Center and ALA, and we provide technical assistance and research and trainings and webinars like this. And I also want to start by acknowledging that the land where the Public Health Law Center is located is in Minnesota, and that area is called Bedote, where the Mississippi and the Minnesota rivers meet, and which is the birthplace and center of all things for the Dakota people, who have stewarded the land since time immemorial. This region is also home to the Anishinaabe and other indigenous peoples from many tribal nations. We appreciate the ongoing stewardship, spiritual connections, and life ways developed in these homelands upon which the Public Health Law Center sits. I recognize that the land the Public Health Law Center currently occupies was forcibly stolen and comes with a legacy of U.S. policy aimed at attempted genocide and oppression of indigenous people, and that nonetheless, this land remains and will continue to be indigenous land. This land acknowledgement is one of the ways the Public Health Law Center works to advance tribal sovereignty and build relationships with the land and each other. Next slide, Luke. I also want to talk about something that is very important to us in the work that we do, and that is becoming harder to talk about lately, it seems like. But all the work that we do is done in consideration of advancing equity. And what that means is that we're focusing on partnering with communities and organizations to use the power of law in a way that addresses the social determinants of health and meets the specific needs of all communities, especially those who unfairly bear a greater burden of public health and other societal harms. Next slide. Okay, and my final intro slide is when we're talking about tobacco today, we're going to be using the term commercial tobacco, and you'll see that term frequently used in Public Health Law Center resources. There are very important cultural considerations when forming commercial tobacco control policy that respects the sacred nature of tobacco, as it may be used for prayer, offerings, and purification. So we strive to respect these important differences in the ways these products are treated in our model policies and throughout our work. And now I'll turn over to Luke to get into the substance of what we're discussing today. Thanks, Luke.
Thank you, Natalie. As Natalie mentioned, I'm Luke Haqq, and I'm a staff attorney at the center, specifically in the Commercial Tobacco Programs California team. Today, I'm going to talk about AB 1775, which went into effect at the beginning of the year. AB 1775 is a cannabis-specific law. Cannabis policy is generally outside the scope of our work, as we are limited to tobacco. But where there's an interplay between the two, we will, of course, help to sort it out as best as we can. Here, there's a connection to our work given the ways in which AB 1775 undermines California's smoke-free laws. I'll first give a high-level basic rundown of what AB 1775 does. I'll then go a bit more in depth into the law, providing the specific changes to the statute, and I'll finally suggest in concluding what localities can do before addressing questions. The basic gist of AB 1775 is simple. The bill was signed into law on September 30th of 2024, and it became effective on January 1st. Prior to its passage, state law had permitted localities to allow cannabis consumption lounges. Now, local jurisdictions are additionally permitted to allow these lounges to prepare and sell food on site, and they can also host live performances. AB 1775 does not preempt localities from enacting smoking regulations that regulate cannabis cafes. Rather, the law is permissive towards local jurisdictions. They remain free to permit or prohibit cannabis cafes altogether. And if they permit them, localities can effectively reject AB 1775 and can prohibit them from selling prepared food and from hosting live performances. AB 1775 just permits local jurisdictions, if they want to do so, to permit cannabis consumption lounges to prepare food and host live performances. AB 1775 also does not create any independent rights for cannabis consumption lounges to prepare food and host live events. Rather, localities must first enact enabling legislation, both to permit cannabis consumption lounges and to permit them to sell prepared food and host live performances. It may be worth noting that the law doesn't define what exactly constitutes a live performance, so if a jurisdiction does move in the direction of regulating such events, it could be useful to have a clear definition. Well, those two basic aspects, permitting food preparation and live performances in cannabis consumption lounges, are the most important takeaways from AB 1775. I can also go a bit deeper into the law. AB 1775 amends Section 26-200 of the Business and Professions Code, which was created in 2016 through Prop 64, and which later became part of the Medicinal and Adult Use Cannabis Regulation and Safety Act in 2017. Prop 64, also known as the Adult Use of Marijuana Act, established California's statutory approach to decriminalize recreational cannabis use and cultivation by adults. In addition, since 2015, the Medical Cannabis Regulation and Safety Act had created a licensing system for medical cannabis, while Prop 64 created a licensing and regulatory system for recreational use as well. The Medicinal and Adult Use Cannabis Regulation and Safety Act in 2017 then brought medical and recreational use into one regulatory framework. Importantly, Prop 64 established Business and Professions Code 26-200, which is titled Local Control and gives decision-making power to local authorities in the regulation of cannabis businesses within their borders, including the authority to impose an outright prohibition on cannabis activity if they wish. The businesses that local governments can regulate include not just cannabis retailers, but also manufacturers, distributors, micro businesses, and others. So the existing statute that AB 1775 amends pertains to the local control of cannabis business regulation. The state law sets a baseline on which local jurisdictions can build. Note that these laws did not originally require local jurisdictions to adopt any regulations to enable on-site cannabis consumption, but rather simply preserve their authority to do so and lay some parameters for it if they choose to allow it. Under this framework, cannabis businesses cannot allow for patrons to consume cannabis on the premises unless a local ordinance explicitly permits it. AB 1775 hasn't changed that. Similarly, there is nothing in AB 1775 that proactively allows for any state licensed cannabis business to prepare food and host live performances. AB 1775 is thus just an authorizing law that allows local governments to choose their own path. Local governments do nothing, then nothing happens. If local governments do choose to allow any of what AB 1775 authorizes them to allow, they must do so within the parameters laid out by AB 1775. We've been concerned with subsection G thus far, the subsection of Business and Professions Code 26-200 that was amended to permit food preparation and live performances in cannabis consumption lounges. There are also background requirements for cannabis consumption lounges delineated in subsection G. That is, local jurisdictions can only allow for cannabis consumption lounges if they meet several conditions. Originally, under the Medicinal and Adult Use Cannabis and Regulation Safety Act, there were 3 of these requirements. First, access to the cannabis consumption lounge must be limited to people aged 21 and older. Second, cannabis consumption cannot be visible from any public place or non-age restricted area. And third, sale or consumption of alcohol and tobacco is not allowed on the premises. So those were the original 3 requirements under the Medicinal and Adult Use Cannabis Regulation and Safety Act. AB 1775 adds several more conditions that must be met, including first, Beyond restricting age access to people 21 and older, each entrance must have a prominently posted sign warning that cannabis consumption, including smoking, is permitted inside. Second, non-cannabis food or beverage products cannot be contaminated or commingled with any cannabis products served or sold on the premises. Third, smoking or vaporizing of any cannabis product by an employee, or customer is not allowed in the food preparation, food storage, or warewashing area. Fourth, the local jurisdiction must consider whether to require adequate ventilation and filtration systems. And I should note that this and the next few items reflect how AB 1775 sought to incorporate greater worker protections after an earlier version, AB 374, was vetoed by the governor, though these additions could be criticized as being inadequate to protect workers. Fifth, employees are permitted at their discretion and without penalty or sanction to wear a mask for respiration, including N95 masks provided by their employer. Sixth, when hired, employees who will be working where cannabis is smoked shall be provided in writing with the Department of Public Health or its successor's guidance regarding secondhand cannabis smoke. Seventh, a cannabis consumption lounge that offers on-site consumption of cannabis products shall include secondhand smoke in its analysis of potential workplace hazards for the purpose of their injury and illness prevention programs. And finally, loitering in or around the business is prohibited. So those are all the additions that AB 1775 made to Business and Professions Code 26200 subsection G. In addition to amending subsection G, AB 1775 also adds subsections J, K, and L. Subsection J states that if a retailer or micro-business license issued under this division is suspended, the licensee shall not engage in activities authorized under subdivision G for the duration of the license suspension. And those activities in subsection G again include having a consumption lounge as well as permitting food preparation and live performances in it. Subsection K states that all non-cannabis food and beverages present on the premises shall be stored and displayed separately and distinctly from all cannabis and cannabis products present on the premises. So a microbusiness could potentially prepare cannabis-infused products as well as non-cannabis products, as long as this complied with applicable laws like manufacturing standards, regardless of whether the cannabis and non-cannabis foods are prepared or prepackaged. Subsection K requires them to be stored and displayed separately. Finally, subsection L states that subdivision G does not authorize a retailer or microbusiness licensed under this division to prepare or sell industrial hemp or any products containing industrial hemp. Of course, there are many public health concerns if local jurisdictions choose to allow Amsterdam-style cannabis cafes that double as entertainment venues. Despite the precautions codified in the law, the risk of cross-contamination is high in the preparation of non-cannabis and cannabis foods, particularly for places that make and sell edibles for on-site consumption while also selling non-cannabis food items. There are significant concerns that AB 1775 erodes labor protections by diluting the state's smoke-free laws. This will expose employees, performers, vendors, and patrons to breathing potentially harmful toxicants produced by combustible and vaped cannabis products, and it'll involve the commingling of food and entertainment with secondhand cannabis smoke and aerosol. So what can cities and counties do? Local governments are not preempted from taking broad action in this area. This includes zoning restrictions, licensing requirements, prohibitions on the sale of cannabis, and comprehensive smoke-free laws that go beyond the state's indoor workplace law. And doing nothing is also an option. So to give you some examples, suppose a locality does not permit cannabis consumption lounges. What happens in their jurisdiction now that AB 1775 is a law? In that case, there would be no change. Local jurisdiction must pass enabling legislation if they want to permit cannabis consumption lounges. If a jurisdiction permits consumption lounges but not food preparation, what happens in that case? Again, there would be no change. A local jurisdiction must pass enabling legislation if they specifically want to permit cannabis consumption lounges to prepare food on site. To sum up, AB 1775 permits localities to allow cannabis consumption lounges to one, prepare and serve non-cannabis food and non-alcoholic drink, and two, host live events and performances. AB 1775 additionally sets parameters that cannabis consumption lounges must meet. If a local jurisdiction does not allow for cannabis retailers or micro businesses at all, or if the local jurisdiction does not allow for on-site cannabis consumption at cannabis establishments, then AB 1775 does not alter that. And again, localities are under no obligation to allow live performances or food preparation at cannabis consumption lounges. AB 1775 just allows local jurisdictions to permit those activities if they wish. Finally, I'll pause for a second on this slide. If you could please consider completing our webinar survey, we'd be quite grateful. And you'll also be receiving an invitation to complete this survey after the webinar, so no worries if you don't get a picture of the QR code. Here's our contact information, and with that, I'm happy to open it up to questions, which Natalie is going to help facilitate.
Thanks, Luke. Um, so the first question I'm seeing is there any language in the bill around these cannabis consumption lounges having outdoor spaces and allowing smoking in these spaces, patios, etc.?
I don't think it makes a differentiation between the two. I know there's a difference for that for the purposes of the state's smoke-free law in terms of whether it's a restaurant outdoors or if it's just enclosed places. I mean, usually that law focuses on enclosed places of employment. But in terms of AB 1775, it doesn't make a distinction between indoor or outdoor that I am aware of.
Uh, Another question Leslie asked, I've heard communities have authorized on-site cannabis consumption based on the argument that because state law allows smoking and tobacco-only retailers, it's an equity issue. How to address this?
Do you have any thoughts on that, Natalie?
Uh, well, I mean, I will say that our model TRL and our model language in general usually closes that exception, and we recommend that jurisdictions don't allow smoking in tobacco retailers. But I mean, I guess I'm not exactly sure what talking points could exist around that. I mean, I think it's something that we could collaborate and discuss, like on an upcoming community practice call or something like that, trying to see if we can put together some information that would be helpful to people and trying to make the distinction between that. But I don't really have a perfect answer right now on how to address it in particular. Um, and Leslie followed up and said that people have been caught off guard. So I think, yeah, I mean, probably what that means is that we should think about putting together some talking points or something. We'll have to think about how to craft those for the need that is arising around that. And then, does the law make any mention of safe food handling and food preparers potentially working while under the influence? That's a great question.
There is part of the law that says that vaping or smoking of cannabis is not allowed in the food preparation or warewashing areas. That's not a complete, I mean, that's not saying that they can't use edible products, for example. So I think that's a valid concern that this law doesn't specifically address whether workers can use cannabis while they're working or not.
Right. And then, I mean, I think what you're talking about here, Shannon, is that there's all these rules saying about no commingling and things like that, but if people are high, are they like somewhat impaired being able to make that those safe choices? And that's a fair concern and question. Irene wants to know, is there any more specific language about like the non-commingling of the foods? Like, does there have to be a certain distance, or like, is anything more specific about that?
There isn't. It just says stored and displayed separately, but it doesn't specifically define separately more than that. I mean, I know so when they talk about adequate ventilation, for example, there is a subsection that talks about what adequate means in that context, but they don't
Mhm.
happen to have it for this. They don't spell it out more.
Thanks for linking the law, Marilyn, in the chat. Okay. It seems to me that populations this was designed to protect primarily consist of individuals working in cannabis consumption lounges and employees or private contractors. Is there a body of health-related complaints coming from this population? It occurs to me that people are likely aware of the secondhand smoke hazards in a cannabis lounge and can simply choose to perform, sell product, or work elsewhere. Was this population surveyed before the law was drafted? I don't think Luke knows the answer to that at all, and I don't know the
That's
answer.
correct.
Um, and I mean, we started off talking about like, we talk about cannabis in the intersection with secondhand smoke, but we don't do a lot of like cannabis specific work. So our depth of knowledge of like how this law came about and what are the health related concerns or complaints coming from the population they're seeking to protect as like not very high, and I'm sorry about that. Does the Public Health Law Center or ALA have any models for possible legislative language for closing or addressing these locally? Um, or are there any pro bono attorneys available in California? Consult with local communities to stop the weakening, I'm assuming. Um, we haven't developed model language, but so because we haven't had to up until now, because like the general principle has been, right, that wherever smoking is prohibited, then also cannabis smoking is prohibited, and this is sort of the first like deviation from that, I would say, in California. But we should we do offer legal technical assistance. So if a community wants to close this gap and needs help with that, we can offer that legal technical assistance as long as it's within the smoke-free realm. And then I take it sort of under your request that like a model would be helpful, and we can work on that as well. I believe the law talks about cannabis secondhand smoke education from the employers to their workers. Do we know what educational pieces that will be provided for the employer to educate their workers, or would it be up to the employer to find and provide?
I don't believe there was anything specifically requiring the employer to educate. There was a guidance that has to be given that would be presumably written by the Department of Public Health. So that has to be provided to employees, and presumably by the employer. But beyond that, I don't think there's education specifically that the employer has to engage in. The employer does have to provide a mask upon request, though.
Is this in conflict with the law that previously banned smoking sections, for example? Can it be challenged?
Um,
Well, so the it's kind of a I don't know if we can actually answer this like super helpfully on this call, because it's kind of a little bit of legislative gymnastics trying to talk through how cannabis lounges exist and why they exist and how they're not in conflict with the law that you're referencing, which is like the clean indoor air law. So I think that question is probably best emailed to us, and then we can like write out an answer for you, because we have to pull up a lot of different legislation to sort of show you the hoops and the different places that the law takes you to try to puzzle through this answer. Oh yeah, so Leslie put in the so that I that's a good point, Leslie. So she put in the chat that um there is a potential to think about challenging this under Prop 64, which says that you can't smoke cannabis in places where tobacco is smoked. So there is some talk, I guess, of challenging it, but I don't know to what extent, how far that's gotten, or if anyone has taken up the helm to do that. Um, Pam asked if we've prepared a summary document. We did. We're putting together an FAQ to put this all together. We do have a blog post about this that has some of this, but we are also putting together a publication. So be on the lookout for that. Leslie gave the update that the lawsuit hasn't really happened yet because they're still looking for an attorney to do it pro bono. Thanks for including the link, Stephanie. Okay, let's see here. So the question is, what are some of the repercussions for retailers if they don't understand AB 1775 and they begin preparing food without getting the locality to pass enabling legislation?
I'm not sure what the penalties are specifically for violating AB 1775. I mean, it doesn't specifically delineate penalties.
Well, I think probably the penalties will come under the local regulation of
Yeah.
cannabis. So either you are in a jurisdiction that doesn't allow commercial cannabis at all, and then it's whatever penalties are for violating that, I'm assuming, and then you're in a jurisdiction that hasn't enabled it, but you have other regulations, you allow cannabis lounges and you establish like a licensing, and those schemes usually have whatever the penalties are for violating. And then they're usually pretty hefty. Um, I did some research on this at one point, and I remember that they seemed heftier than tobacco ones typically. Who's the enforcement entity in AB 1775?
That I don't know. I
Neither.
don't have it up with me right now.
I'm sorry. You are kind of catching us in like the realm of like things we don't know because we don't do cannabis work like as regularly, and our intersection is so narrow. So I'm sorry that we don't know who typically enforces the cannabis laws. I think that there is like
I mean, I
some.
believe it's the Department of Public Health. At least that's the one that's named in there, but that's specifically just referred to providing guidance, not with respect to enforcement. I don't know if there's other agencies named in AB 1775.
You can't, Pam, are you saying that you can't copy the links from the chat? Sorry.
I'll be sure to include any links on our the resource page with the recording that we'll get out. So I'll be sure they're all in one page for everyone.
Okay, so people, yeah, they're saying, I think this falls under the Department of Cannabis Control, which I kind of
Yeah.
figured. I think that's probably true. So I think the enforcement of most of the state level cannabis laws are there, and it's just living within the state cannabis law. I think there was one more question. I heard you can sell cannabis edibles at farmers markets. Is this true? I don't think that this bill had that in there, did it, Luke?
No, I can't think of a provision that would relate to that.
I'm not sure if there was another bill that had that, but I don't think it was included in this bill. Well, I think we're at time, and I think we maybe got through most or all of the questions. Oh, there's one more question. Let's make this the last question. Are there differences in retailers licensing when they allow for on-site consumption, assuming the local jurisdiction enacts enabling legislation? Does it mention anything in the bill, Luke, that you remember that says that they have to get like a special license?
A license for on-site consumption?
Yeah.
No, not in AB 1775. That's not something new from that.
Okay. I'm not aware if the general cannabis law had already had something like that for cannabis lounges or not. All right, well, thank you everyone for coming. If you have questions that weren't answered and you want to email us, I'm going to make sure I put, or Luke and I are going to put our emails in the chat, although you can't copy and paste, I guess, so maybe that won't be super helpful, but hopefully you can find it. We're like the point of contact on partners and whatnot, that you can find my email there, or Lena from ALA, and get in touch with us to ask us any question that we weren't able to answer. And we'll try to answer all the questions that are within the realm of the intersection of tobacco and cannabis smoke. Thank you.
Thanks, everyone.